have the big picture about what's happening, like the setup of the forest governance system. Let's talk about shared illegality risk in those countries. So just a very, very quick reminder that we have 5, the UTR is like targeting 5 different legal categories, so right to harvest, payments, timber harvesting itself, third parties legal right, and trade and customs. So I'm going to go over those one by one. An operator, when doing its due diligence, should ask itself what are the specified risks in the country of harvest, and if they're relevant to the supply chain being assessed. So let's first look at legal rights to harvest. Laura, I just want to check that you've launched the recording again. Yes, okay. So land tenure conflicts are quite frequent. As I said, most of the time there can be a question whether it's outside the legality, because sometimes customary rights will conflict with formal law and formally incorporated land into the state domain. So that's one point to keep in mind. I don't have a lot of, since there's no private forest there, it's highly unlikely that there will be a conflict between 2 private entities, right? It's usually land tenure will be a conflict between the state and local communities. That's the first thing. Other than that, issues can arise around the forest title attribution process. So illegalities can happen where there's a failure for a concession holder to meet a specific deadline to update its forest titles. So that has been the case in DRC for a long period of time. So the forest code changed the forest titles, and companies had a certain delay deadline to update this, and this process really dragged on for years and years and years. That's the one thing that can happen. Most commonly, you can have a failure to implement the attribution process in place. So I was mentioning open bidding steps. And I think that there's a recent report in DRC where concessions were awarded, like new concessions were awarded without this open bidding process that's prescribed. But also it can be about the different steps. So I've heard of cases of illegality, for instance, where the government attributed a concession before the end of the open bidding deadline. So entities were still formally allowed to apply, but then the result came in before the end of the process. So that sort of thing can happen. Or the wrong committee is taking a decision. So legally it should be a ministerial committee. And then the committee that takes a decision is not the appropriate and allowed body, public body, the proper authority in charge. So that sort of thing about respecting the process in place can happen, and there's common risks of illegality or irregularity there. It's also linked to corrupt practices. Of course, this granting of authorization and the process of competing against other private entities to secure the access to resource is kind of the ideal setup to encourage corruption practices. Right, so that's how you attribute the forest concession. Risks around management planning, that's quite a long list here. So around management planning, the risks can be, first, the failure to meet deadlines to have a final approved forest management plan. This is also extremely common. And so logging will continue to happen despite the fact that the process is still ongoing or is not even launched by the company, despite the requirement of legal frameworks. There can also be an absence of medium-term and annual management planning documents, or they are late or they're not approved. Risks are also around the failure to actually enforce the required steps. So as I said, like different studies or inventories that you need to conduct that can be not properly implemented as is prescribed by the regulation in place. The risk can also be about the absence of approval. So the document is here, but it's not been approved by the administration as it should be. Question can also arise about the quality of those management planning documents. Again, that's a bit, it's really tricky, and you really have to look at the legal framework in place and kind of be a legal expert to determine whether that is conducting to illegalities or not. And it's the same for the failure to actually implement planned management activities. That sometimes depend on the sanctions that are planned in the forest code. Sometimes it is sanctioned to not properly implement management activities. Sometimes it is not sanctioned, and it's not very clear that it's an illegality in itself not to do so. In general, around management planning, there's a poor control from states because it's resource consuming. It costs a lot of money and energy, and it's difficult. So the control from states around the whole management planning and implementation of management activities is quite low. And the final point is that also management activities are not always connected to logging. So that also raises the question of if a forest management enterprise, let's say, does not conduct the assisted regeneration it was supposed to do in this annual area, is the timber logged in this annual area considered illegal or not? That's another thing. Like that's another debate. But something to keep in mind on the risk linked to management, forest management. Logging authorization permit, well, it's kind of the same that for management documents. There's a risk of non-complying with the administrative process in place to secure those documents. But also there's a risk of not complying with the period of validity. So logging might happen before or after the valid period. I've seen this over and over, that the forest management enterprise will start logging as soon as they have a phone call from the administration saying that their permit is going to be delivered, and they don't wait for the issuance of the documents and to receive the documents. They'll just run into the forest and log. That's quite common, that there's this discrepancy. That can also happen, that logging is continuing after the period of validity of the permit. And then you can also find use of invalid permits. So logging will happen with a permit that's been delivered for a totally different area, and that's actually not connected to the areas where logging is happening. Absence of environmental impact assessment is another one. I have to say that, in my point of view, legal frameworks are quite unclear, because usually legislation providing for the obligation to conduct environmental impact assessment are not drafted by the forest ministry or bodies, and there's kind of a debate as to whether it applies to forests that undergo a forest management plan. And it's a bit unclear for me, like in most of those countries there are provisions on environmental impact assessments, but it's not very clear who has to do it and how does it apply to managed forests. But there can still be things to look up for in this area. So that's for the first legal category, legal right to harvest. So securing the resource and actually having the right to go and harvest the resource. If we look at taxes and fees, the issues and risk of illegality will be based on basically paying less taxes that the forest management enterprise should pay, because it's usually based on a declarative system. So except for the surface tax, that's quite easy, but the volume tax is based on the declarative system. So basically the company will declare that this year it has been harvested that amount of cubic meters of timber, and of those and those species. So it's really a declarative system, and the control to verify that those declarations are true is quite weak. So what can happen is a misdeclaration of species and volumes to lower the amount to pay. And another thing that can happen is the absence or undue delays in payment. That can also happen. And in DRC, there's a debate about which surface should be taken into account to pay the surface tax. so there's a debate around what's the area that should be taken into account to figure out the amount to pay, these annual surface tax to pay. So those are the risks linked to taxes. Timber harvesting. That's, I think, one of the most interesting parts. The first common risks is a failure to comply with the logging permits and logging provisions contained in management documents. That can be linked to which species you have the right to harvest. So in most of those countries, there's not a lot of tree species that are protected at the national level, and that's where the national law will say you cannot log this and this and that species. Sometimes it's just like a small list of 3 or 4 species which are protected at the national level. However, they can be protected by management documents. And you can see an extract here in Gabon where you see a list of, I don't know, maybe 20 species which are excluded from logging by the management plan. So as an operator, if you don't go and look in the management plan, you can easily miss this, requirement that those species cannot be logged in this forest. And I've seen it on the ground in Ivory Coast, where 4 or 5 species were prohibited in the management plan, and everyone kind of forgot about that. And so those species were indeed logged and traded, and exported abroad. So volumes also can be not respected, so that's overharvesting. And that's also quite difficult to catch and to verify, be it for the state, so even more for an operator that's in the EU at the other end of the supply chain. Logging areas also, I've seen like First Management Enterprise going like slightly beyond their annual area because there were a few trees that were of interest to them beyond the limit of the annual area. And sometimes beyond the limit of the annual area can be the protected area of the forest. So that can be quite problematic. So those are the main things, but other restrictions and conditions, diameters and stuff like that can also be prescribed in management documents and logging permits and not respected on the ground. Further than that, failure to comply with logging technical rules can happen. So that can be, so there's usually a bunch of regulations linked to how you should mark stumps and logs in the forest, which diameters you can harvest, how you can harvest, and the fact that the Forest Management Enterprise need to control logging so that they need to be able to do a limitation of damages when the tree is logged to avoid damaging the resources. When the tree also is pulled from the stump to the log yard, to the first log yard, that's also when a lot of damages can happen to the surrounding resources. So there can be rules around that. Also, use of machinery. Some machinery can be prohibited, but also how a company can use and build infrastructures to extract the resources. So that can be bridge, roads and paths, log yards, how big can the log yard be, etc. There can be also rules on the follow-up on site. So usually companies need to have a field logbooks where all the events and all the tree harvested should be noted down in the logbooks. And so sometimes those logbooks are non-existent. And yeah, finally, leaving timber in the forest. So companies usually prohibited from leaving commercially viable timber in the forest. Sometimes forest management operators will log a tree and then it will have a small defect. And so they will decide to leave it in the forest. And of course, they won't pay any taxes on this tree because it won't be recorded in any of the trade and transport documents. So that's usually prohibited by regulation in place. Last but not least, about timber regulation activities. That's not super explicitly covered by the UTR, but we do like to put it in our timber legality risk assessment. Health and safety regulation and labor regulations are very often non-complied with. So the main thing would be wearing personal protective equipments, and providing for those equipments and making sure that they're used on the ground, but also providing health check and access to health professionals if there is an accident in the grounds, but also labor regulations, so having your employees having a regular contract, being paid the minimum wages, prescribed leave, working hours and schedules, etc. So those are high-risk area, let's say, in those countries. So that's a lot of risk, as you can see, and I'm not done yet. Third parties' rights. So basically, illegalities about third parties' rights would be either irregularly restricting the access or usage right of third parties to the forests, so not complying with the forest management plan and the legality of their rights, but also damages to cultural and spiritual values, so logging trees which are sacred trees or damaging cultural areas. It can also be not having the required bilateral social agreements in place with the local communities, or simply failing to actually implement those bilateral social agreements. That's a vast area. That's quite interesting, but that's the main idea. That's the main risks. Trade and transport. I'm going to try to be brief. So as I said, that's kind of overlapping with the taxes problem, because usually irregularities on prescribed transport document is linked to the will to pay less taxes. So it will be sometimes misdeclaration about species or volumes, diameters on transport documents. It can also be the absence of validation from authorities, which might be required to sign and stamp transport documents. Failure to comply with export procedures is another one. Export procedures in those countries are complicated, very long, very lengthy. So sometimes companies might be tempted to take shortcuts, or there might be missing required document in their export package. But yeah, I wouldn't say it's the main risk, but it's still there. Non-compliance with prohibition or restriction on log export is very strong, especially when it's just restriction, because restriction opens the door to exceptions, and then it means that there's a need to follow up on who's doing what. And I think in Congo, up until recently, up until the last forest code was in place, there was kind of a market for quotas to export logs. And so companies were able to extend quotas, and that's like very difficult for the state authority to follow up on who's doing what and where is actually the timber coming from. So that's a risk here. And last but not least, offshore trading. So profit taxes evasion, quite common in those countries because they usually have a really high a level of taxes on profit, right? So it can be tempting, and there's a bunch of reports for the Congo Basin, especially, so Congo DRC, I think, highlighting companies selling logs abroad or timber abroad at a quite low price. So the profit that's made in the country is quite low, and this timber is sold to a company abroad in a country where the profit taxes are quite low, and then sold again to an importer, let's say in Europe, and the timber never goes to the intermediary, so it will go straight from let's say DRC to Europe, but there's a high profit that will be made in this kind of offshore company abroad. So that can happen. That can happen. I'm going to end this general bit with CITES. I'm going to try to be a bit quick because time is running. But so basically, I'm going to go a bit off track here because a CITES permit is kind of exempting the product from due diligence and the UTR. So an operator will not have to conduct due diligence, which does not mean that there's no problem of irregularities on the ground. I'm also not sure, as CITES competent authority in the importing country, how far you can go to question the validity of a license. So again, I'm also not going to talk about that. I'm mostly going to talk, about what's happening in the ground. So, so you can have an idea of the potential weaknesses and problems arising from delivering CITES export licenses. So the main species concerned with CITES is Asamela or Afromosia, so that's Pericopsis elata. There's also Bobinga and Prunus africana, which can be involved, but what's more common for me to see is Asamela. That's the main thing. Just a few words to say again that before a country can attribute export permit, the scientific authority needs to elaborate a non-detriment finding, so saying that the resources can be harvested, like exploited and exported without any detriment to the species. In general, I find online, at least, there's only a few NDF that are publicly available. It's not very clear to me if it's an obligation that there's an annual NDF, because it's not only, I mean, the result of it is kind of establishing annual quotas, but yeah, that's an area where I'm not super clear. There's one on DRC that's online that's quite interesting. It dates back from 2015, but it has quite interesting information, and you can kind of see the whole process behind that. So the first thing is that since most of the forests are supposed to be managed, so you're supposed to harvest the resource sustainably, like for all the species, CITES or non-CITES, right? So at least for this DRC1, the process of establishing export quotas is linked to the forest management process. That's supposed to figure out annually what's the sustainable yield by species for this annual unit in the FMU, right? So it's basing itself in the annual operational plans that derive from the annual inventory of the resources. So the overall annual country export quota is linked to the sum of all the annual harvest volumes by forest management units, right? So there's this kind of first step where, if you consider that forests are managed, the export quotas is linked to the sustainable yield for the species by managed FMU. The challenge here is that approving a sustainable harvest of one species does not necessarily equal to legal harvesting, because there's a lot of things that can go wrong in between. So for instance, not obtaining your normal harvest permit, or sometimes a special harvest permit that you need to obtain for some species, not respecting the volume prescriptions, not respecting the prescribed diameters, how you do controlled logging, etc. And checking the legality of the harvest on the ground is not really embedded in the CITES process to grant export permits. And it's quite difficult for CITES authorities delivering permits to actually have an idea about how the harvest has been conducted on the ground. So that's one thing. Those illegality risks around how you actually conduct harvesting do not really go away, even if there's an approval that you can harvest a Samela for this given year in this given area. Another big challenge is that there's an important lag between when the logging happens and when the export happens, and that makes following up on quotas and compliance with those quotas extremely difficult. The transport from the forest takes time, processing like at least the first transformation, and then the whole export procedures, they take a lot of time. Moreover, annual units can normally, generally, they can stay open to logging up to 3 years. So normally it's like exceptional, but in theory it can happen. So an annual unit can be logged up to 3 years, but the annual quotas are set up for a given year. So that adds on to the lag between, so in theory, you could log a species in December of year 3 of the annual, your annual units. And so by the time you export it, it'll be like 4 years later. The attribution of the quotas that is based on the determination of the sustainable yield for this annual unit. So that's giving a high level of confusion on how to keep track of all of that. And I quickly want to show you that that's the DRC NDF. That's kind of thinking about a way to have a rolling quota. So basically, each year a quota will be open, and it will roll for 4 years. So each year you'll have like kind of 4 tabs open for quotas for each annual harvesting period of time. It's a bit complicated, but they thought about it. It's a bit complicated to understand. I am actually not sure how they implement it on the ground, but that's just how to show you that they're thinking about that. And in Cameroon, there's been a report last year in 2020 that that points out to exactly this problem. So they're saying, okay, there's 6 companies that were not supposed to export in 2019, but they were supposed to export in 2018. So maybe because the permit is 6 months valid, maybe that was because it was the quota from last year, but we're not sure. And basically, it's all very confusing for everyone. And that leaves the door open to cheating, basically, because that's very easy, because the follow-up of all of that is extremely complex, especially when you think that the administration is weak and IT system in place are weak, and so the whole follow-up of quotas is quite complicated. A few more points, but those were the 2 main sources of concern for the attribution of CITES species. There's also sometimes a confusion about institutional roles. So CITES is concerning much more fauna species, so sometimes there's a confusion about who's supposed to grant export license, and kind of overlapping in responsibilities, and the fact that fauna ministry do not usually interact with the forest ministries, and there can be sometimes a confusion about those responsibilities. The process of obtaining the export license can also be at risk, because as for any legal authorization processes, it's prone to corrupt practices and irregularities, to go faster, and to not provide that document or that document, etc. And overall, there's a poor level of transparency and poor traceability in those countries, which do not help. And that's true for all species, but specifically CITES species.